Greetings and welcome to this Storybooth preview of the 9th Annual University of Florida Levin College of Law E-Discovery Conference. My name is David Horrigan. I'm Discovery Counsel and Legal Education Director at Relativity. And this one is one of my favorite story booths because this is the Go Gators story booth. We have with us today Scott Milner, partner and part of the eData practice at Morgan Lewis in Philadelphia. Of course, he's been at other Morgan Lewis offices. Scott Milner, Go Gators. And what do we have here? Actual Gators coming up, orange and blue. They are Gators going along. It's, one of the things we bring up at this conference is sharing ideas, sharing what we believe, what's going on. And what a success story in e-discovery you are. You started off doing e-discovery, you moved, and now you're a partner at one of the biggest law firms in the world, running a cutting-edge practice. Scott, why don't you take us back to how you ended up in your current role and your tour through e-discovery?
Absolutely. And one, thanks for having me on this. I always love giving back to the university and advancing law, and what University of Florida has done with the e-discovery conference is amazing. So take me back to 2002 when we were cool. I got out of law school, wasn't really sure the area I wanted to practice, and I actually joined Morgan Lewis on a contract basis and supported some toxic tort litigation. And I was working with a very brilliant associate who said, hey, discovery can be specialized. And long story short, I was in warehouses collecting boxes with tons of paper cuts back in the good old days. And we started to find some microfilm, microfiche, some floppy disks. And we're like, what do we do with this? And then from there, we just started to build out process. And so we took the examples from that toxic tort litigation and then started to replicate it. And then we started to form out the managed review business and supporting firms and clients across the firm, not only in the US, but then also outside the US. And then from there, it just became, all right, e-discovery is a real thing. And with Zuba Lake and the UBS Coleman cases, you started to build a career. And then we saw the industry balloon. And now I'm just so thrilled to be part of a group that has over 40 full-time attorneys, 60 full-time technologists and other professionals. And that doesn't even include our contingent workforce supporting our managed review practice. Being able to lead and be part of such a growing and unique industry it's been incredible.
Scott, they say that for better or for worse, the United States is the capital of litigation around the world, and it's certainly the capital of e-discovery, although we have high respect for many of the practitioners across the world. But you haven't just been at headquarters in Philadelphia. You've been with Morgan Lewis in Paris. Tell us about what you did there, what brought you there, and how things are different and how they're the same.
Well, it was a complete learning experience. And I primarily, although living in Paris, I did a lot more work with our London office. And so I've got to learn a lot about the disclosure process. And it's just completely different because you're effectively identifying from the jump what you anticipate disclosing, what the cost of your disclosure will be, and the scope of it. And in the States, for years, we talked about testing your search terms, identifying data volumes. When I was there, I had to learn a lot more about you're just making a lot of guesses and hoping you're right, trying to gather as much information as you can. So I was lucky enough to support our disputes practice in Europe, building out, again, similar to what we did in the States, looking at ways to leverage technology, building out templates that allowed our litigators to be more thoughtful in how we presented our topics of discovery and disclosure. And then lo and behold, GDPR and Brexit and all the other fun stuff that started to happen while I was there. And then here comes the DSARs, the data subject access requests, a whole new type of disclosure and discovery, which really isn't supposed to be disclosure or discovery, but we all know they're often used for free disclosure and discovery. So it was a really good experience for me to kind of get a global perspective of how organizations felt. And also, candidly, learn a little bit more about why they were so hesitant for data transfers to and from the United States. And it put a lot of things in perspective, working for a global law firm with many of my clients operating outside the US.
As usual, Counselor Milner, you provide an excellent segue and you bring up DSARs. And of course, those are data subject access requests under the European General Data Protection Regulation. But it's also come home. There are also these DSARs under relatively new California laws. And the reason it's a great segue, it's into our panel. You're speaking on multiple panels, but you and I will be getting together for a panel on the second day of the conference. That's Thursday, March 24th. And that is data privacy, data protection, and recovering from a data breach. And DSARs are an important part of that. We're going to have Ryan O'Leary, who is an attorney and also research manager for data privacy and research at IDC, the international analyst firm. He's going to share a bunch of the data on DSARs, but we're going to turn to Scott Milner, the guy in the trenches who's actually dealt with these things. So just a brief snippet. We don't want to give away the whole store because we want people to come on the 24th. But in dealing with DSARs, what is some of the things that have really kept you up at night?
Just finding all the data. It's a different type of exercise. I mean, there's a lot of parallels to our traditional e-discovery, but finding the data, how you craft search criteria to identify what is personal information and what is actually subject to disclosure in the DSAR process. So I'll leave it at that. You don't want to miss the panel because we have a super special guest that's going to be speaking that I'm even thrilled. I'm almost rather be in the audience than on the panel for what you're going to hear during that panel on that side.
Yeah. And, spoiler alert, it is our e-discovery colleague, Victoria Edelman. And she is going to tell us how Capital One made a great recovery from when they sustained a data breach. And the story, it's not a question of if you will sustain a data breach, but when. So the wisdom on that little fact pattern that we're going to share with you is great. And we'll, of course, have Scott Milner on it, Ryan O'Leary, as I mentioned, from IDC, and Kenya Parrish-Dixon of Empire Technologies Risk Management Group and a former government lawyer. So we're going to put all these pieces together, the practitioner, the government, the data, and of course, the case study from Capital One. And Scott, we're looking forward to it. And of course, looking forward to seeing you personally in Gainesville when we get down there. Scott Milner, thank you for being here.
Well, if you're not joining the UF conference, you're missing out. So I can't say it enough. Go Gators.
Go Gators.
The most, I think, amazing panelists and great content. So hope everybody will join.
As do we. Scott, thanks again. We'll see you in Gainesville.
See ya.